student democracy.
Jacinda Ardern.
To speak on Clause 9, and as my colleagues have pointed out here, we are discussing the transitional provisions of this bill, and I think a really important point has been made around the suggestions that we've put forward to the member and the chair around the transition provisions, that this is really an opportunity to prove that this is not an ideological issue. If some of the amendments that we put forward were adopted, that might go some way to alleviating that concern. I give the heavy caveat of some way, because ultimately I would still probably believe this is purely ideological. There's two quick points that I wanted to make around Part A. A student to whom the section applies continues to be a member of the Students' Association until the expiry of his or her current term of enrolment. So obviously the impact of that is going to be that we're going to have a gradual, potentially a gradual depletion of student association numbers, and the impact that that's going to have on the ability to keep student association services up to the level of that would be provided if we had full membership. And probably the best example I can give on that is what would happen in New Zealand if we only had a quarter of the country contributing to services which require universal provision. So if we only have a quarter of the country contributing to roading, to schools, to health services, and health services is actually a direct parallel. If we've suddenly got the phasing out of students providing, contributing to those services, but economies of scale require that you can have no less than one nurse or one doctor available, we can almost guarantee that despite those students still being enrolled to those student associations and requiring those services and expecting those services, the depletion of resources going into those areas will gradually mean that they won't be able to be provided to the same level. So the transitional provisions, I think, will ultimately lead to the gradual decline of those services, as will this entire bill. In fact, this is only delaying to a certain degree the ultimate inevitability of the depletion of services and advocacy for students on campus. But although, as we've already pointed out, that's ultimately the purpose of this bill. I do want to come to some of the proposed amendments from my colleague Grant Robertson, because I think they require a response from the member and the chair. I'd like to make a bit of a reflection that if we are treating this as a true democracy, then the most important part of a true democracy is the ability to communicate with those who have an interest in the details of student union membership. Now, if it's impossible to communicate with the individuals in question, then that is an erosion of that democratic principle. And so I think it's absolutely pertinent that Grant Robertson has put forward a clause which suggests that under Clause 9 we add bar 3, the institution, obviously the tertiary provider as it were, is to provide its student association with the following details of students for whom any membership fee of the kind prescribed in the bill is currently collected from: A, the student's full name; B, the student's contact address; C, the student's contact phone number; and D, the student's email address. Now, just like in elections, we're able to make contact with individual constituents via an electoral roll for the purposes of communicating in a general election. I think it makes absolute sense. It makes absolute sense that student associations are able to communicate with potential members around the services they can provide via membership. Now, if this was truly about giving students choice, then surely a fundamental principle of that is providing the information in order to make said choice. So I cannot see how anyone would have a problem with such a common sense clause. And secondly, and equally as important, is the ability to provide information about the services themselves. So having the contact details of the person you're communicating with is one thing. The ability to provide adequate information is another, which is why Grant Robertson again, I think very wisely has put forward another amendment. I'm a terrible name dropper, Grant Robertson. I'm yet to mention other learned colleagues in the House. Paul Quinn, I see is here, Simon Bridges, I'm sure will make contributions to this bill as well. But under Clause 4, the type of information referred to in subsection 3 includes the services the association provides, members, non-members, the fees and levies, and the process of electing. Mr. Chair. Mr. Chair?
Jacinda Ardern.
Oh, thank you. And the floor is mine. Thank you, Mr. Chair, because I hadn't quite finished going through this proposed amendment from Grant Robertson, which is about the provision of information to students. So not only does it set out the type of information, which of course is incredibly important, students deserve to know that if they are going to be contributing a fee or levy, they do deserve to know what they will receive for that fee or a levy, in the same way that someone who's putting them forward for election is able to provide for their constituents what they're able to provide as an elected representative. So similarities there, which are just basic principles of democracy. But I think it's important to also point out that in the fourth area there, he's also added D, the process of electing representatives of the association. So indicating there that from the outset, those who are opting in to an association, because that's exactly what this entire bill is going to prompt, that they have the ability to see from the very outset what process they can expect for electing representatives of the association. Good common sense clause. And prior to clause 4, though, he's also added, despite sections 229A to 229CA, information must be provided by the institution to both prospective and current students about any student association at the institution for the purpose of informing the student about joining the association. Now, my question is, if the member in the chair is unwilling for us to explicitly set this out in the legislation, what information can we expect students to receive? Because essentially, without this clause, we could expect them to receive nothing. Absolutely no information about those services, their rights, their access to them as advocates, the process that is undertaken for electing representatives. And that is just not good enough. So I ask the member in the chair, demonstrate to us that in your mind, this is genuinely about democracy. I have already given the caveat that I'm unlikely to believe that in any case, but demonstrate to us that with these, by adopting these simple common sense provisions about information, the right of access to information, demonstrate to us that this is about choice for students. Because under that criteria, these provisions should be adopted. And if they won't be, I think this House deserves an explanation. But I do think, though, in broader terms, the use of the term democracy has been bantied around and misused by the other side of the House in regard to these provisions in the bill generally. Because as the member who previously spoke before me, if this really was about democracy, there was already the provisions which allowed students to trigger a referendum if that is what they wanted. That hasn't happened, which is why in debating Clause 9, I do ask that the Chair directly address why it is at the 11th hour you are unwilling to add a provision that would enhance what you claim to be the ultimate principle of this bill. The member in the chair, not you, Mr. Chair. There are double Roys in the chair today, which means probably I'm okay. And what I've just said. So I do look forward to member female Roy, Heather Roy, responding to those. To that challenge, because I think Grant Robertson has crafted them with care. I think he has put some thought into how we can improve these last transitional provisions of the Education Freedom of Association Amendment Bill, and it looks like that member Roy, Heather Roy, female Roy, is potentially about to perhaps, I hope, get on her feet and tell me whether or not she's likely to adopt those provisions. I did see the whip come over, so perhaps that means she's corresponding with him about how we can introduce those provisions. So thank you. Mr. Chair.
Honourable Heather Roy.